BWF solicitors, we take pride in our client service. As a niche law practice, we are conscious of the demands of our clients. We always offer a friendly, listening ear and sympathetic attitude. We've worked with thousands of people all across the UK in all areas of personal legal services. We have received great feedback and reviews from our clients. We are located at Seven Sisters in Tottenham on the 4th floor of the Anna House, right on top of the Victoria Line train station for your utmost convenience. We have a friendly office and provide all of the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence and conduct as part of our responsibility to uphold rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society accreditation helps to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. BWF solicitors, we're here to help you with your legal services when you need us.
Victon Estates provides professional and reliable service to landlords, investors and tenants. Our mission is to ethically and honestly serve our clients. We won't make promises we cannot keep, rather. We present a clear picture of the reality we can offer. We are here to help you with long and short-term let, property management, cash buyers for quick sales, stock repossession and mortgage arrears. For all your property needs, look no further. Visit us at www.victonestates.co.uk or call us on 07448619711. Victon Estates, your property is our pride.
Hello. Welcome to Heritage TV, the Legal Hour show. You are welcome. Today, we've got a representative from BWF solicitors, and she's a very familiar face. But before I mention her name, without these sponsors, we'll not be able to come your way every Saturday from 12 noon. And our sponsors are, of course, BWF Solicitors, your #1 immigration law firm in London. And Victon Estates Limited is a property management company for all your property needs. And lastly, Eagle Heights International School. It's a Maths, English and Science Extra Tuition Center. And they've got a very good track record. If you want your child to be the best in education, contact them on 075 437 07121. Today's topic is no recourse to public funds, the lifting or duty to not impose this restriction on a person's leave to remain. And as usual with me is Mrs. Eunice Achampong, seasoned solicitor at BWF Solicitors and also a partner at BWF Solicitors. And Laura Eunice is ready for us. Hello, Laura Eunice, you're welcome.
Thank you so much, Vicky.
How so far been good?
Yes, by God's grace, our week was good, and hopefully yours was also a good week.
Today's show, I'm all excited every Saturday morning. Today we are going to give the show a slightly different twist. We can go straight to the top. I'll use dates to the update today's topic. So, Eunice, how did you go for us today?
Okay, thank you so much, Vicky. First of all, I just wanted to wish my niece, who was also my flower girl at my wedding, Michelle Osei, a happy birthday. It was her birthday on Thursday, and I pray that God will continue to endow her with wisdom, with knowledge, and with understanding. May she be an example to her peers and to everyone around her. And I also ask that she will be a person that will be steadfast in whatever she has doing. So Michelle, happy birthday to you. So just in brief, we all know of our closing deadline of the 30th of June 2021 for those who would like to make applications to the EU settlement scheme. And then we have those that have made applications as family members to join their EU national family members who are here in the UK. And those family members who are outside of the UK would usually apply for something we call EA family permit or an EUSS family permit. So an EA family permit would usually be a permit of 6 months, which would come under our former EA regulations 2016. Whereas an EUSS family permit is one that comes under our EU settlement scheme. And so those that are close family members of an EA national who is living in the UK or was living in the UK before 31st December 2020 would say ordinarily that they are joining that EU national because they have also applied under the EU settlement scheme. So now we have the case where people who have made applications for EA family permits would now have to realize that because the closing date of 30th June 2021 is very near, all EA family permits will end by that date as well. And so, unfortunately, if you are granted an EA family permit for 6 months to come and join your family member, and you are not here by the 30th of June 2021, then unfortunately it would no longer be valid after that date. And so, of course, if you are granted an EA family permit because you've made an application to join your EA family member here in the UK, or you have won your appeal and you are saying that, of course, you have been granted EA family permit, that permit will no longer be valid after the 30th of June 2021. And this is something that the Home Office has now put in their guidance and on their website as well. And so that means that anybody in such a situation will then have to look to make the application probably under the EU settlement scheme because they are saying that as of the 30th of June, this permit will no longer be valid. Whereas those who make applications under the EU settlement scheme will still be able to join their family members after the 30th of June 2021. So if anybody is within that category and obviously is awaiting an EA family permit rather than an EUSS family permit, then of course they should bear this in mind as well. But if they need any further queries or information, they can give us a call.
Okay, that. So, before I ask you to delve into the topic for today, as usual, I'd like all our viewers, listeners to send in all their questions. I've realized that people wait to end before they ask questions. I don't know. So please, if you send your questions after the show, I'm not a solicitor, so I'm not able to answer your queries. The best thing I can do is to send the details or send your winners details to you at her. But I believe that you take the opportunity to ask. Why not take the opportunity to see the questions house live, on air? So please send questions on Facebook. And now, we are live on BWF Solicitors Facebook page. You either send messages to Heritage TV Facebook page or BWF Solicitors Facebook page. And myself, the university will be able to put these questions to be discussed. Yeah. So, yes, what are public restrictions?
Okay, so in terms of our topic, we all know that most people who have lived to remain in the United Kingdom will usually have this restriction put there that there is no recourse to public funds. And so when you talk about public funds, what the immigration rules and the immigration rules has under the definitions at paragraph 6 that public funds are usually benefits that somebody who is on low income or who financially is not capable of maintaining themselves and any child would have available to them. And so these include things like working tax credit, child benefit, child tax credit, housing benefit, council tax credit, council reductions, job seekers allowance, personal independent payments, things like maternity allowance. So all these things will come under what we call benefits or public funds. And so somebody who maybe has this restriction may only usually be available to have access to something that we call contribution based allowances. So, for instance, if they're working and then they've made certain contributions to their NI and they lose their job and they want to get some job seekers allowance, it will be mainly contribution based job seekers allowance that they will be getting, or contribution based support and employment allowances. Of course, if you're on maternity and you've accumulated the number of months that you need to accumulate to get maternity pay, those will be eligible to you, or somebody who has gone off sick will be eligible to get sick pay or maternity pay. So those ones are not benefits, but all the other ones that I mentioned before are things that will come under the category of public funds or benefits. And the government has made it clear that anybody making these applications should be able to maintain themselves and also accommodate themselves. And so the expectation is that because you can maintain yourself and accommodate yourself, we shouldn't give you access to the public purse. Unless, of course, you have indefinite leave to remain, or you are British, or you are an EA national who came to live here before the 31st of December 2020. And of course, those that have humanitarian protection or asylum leave. So, of course, the restriction is there just to maintain and to assure the public that those that are immigrants will not come and take from the public purse, because they can accommodate themselves and they can maintain themselves and they can contribute to the society. So yes, immigrants who come here also contributes rather than take away from the public. And so in a way is trying to assure the public that they are doing their best to make sure that those immigrants that
BWF solicitors, we take pride in our client service. As a niche law practice, we are conscious of the demands of our clients. We always offer a friendly, listening ear and sympathetic attitude. We've worked with thousands of people all across the UK in all areas of personal legal services. We have received great feedback and reviews from our clients. We are located at Seven Sisters in Tottenham on the 4th floor of the Anna House, right on top of the Victoria Line train station for your utmost convenience. We have a friendly office and provide all of the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence and conduct as part of our responsibility to uphold rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society accreditation helps to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. BWF solicitors, we're here to help you with your legal services when you need us.
Victon Estates provides professional and reliable service to landlords, investors and tenants. Our mission is to ethically and honestly serve our clients. We won't make promises we cannot keep, rather. We present a clear picture of the reality we can offer. We are here to help you with long and short-term let, property management, cash buyers for quick sales, stock repossession and mortgage arrears. For all your property needs, look no further. Visit us at www.victonestates.co.uk or call us on 07448619711. Victon Estates, your property is our pride. Victon Estates provides professional and reliable service to landlords, investors and tenants. Our mission is to ethically and honestly serve our clients. We won't make promises we cannot keep, rather. We present a clear picture of the reality we can offer. We are here to help you with long and short-term let, property management, cash buyers for quick sales, stock repossession and mortgage arrears. For all your property needs, look no further. Visit us at www.victonestates.co.uk or call us on 07448619711. Victon Estates, your property is our pride.
Hi, ladies and gentlemen. My sincere apologies for the slight hitch. The good news is that I'm back. Laura Eunice, are you there?
Yes, I am.
I guess you missed this slide for a bit.
It's all good. I'm so used to this now. I think that I need to start being a pro at doing all these technical things now.
Sometimes we can't do these technical issues. But conditions have to be satisfied. If you want the no recourse public funds should not be imposed on.
Okay, so if you look again at our immigration rules, it sets out the criteria that the Home Office or general caseworker will be looking at if they were to look at a person's circumstances and whether they were to lift or to not impose no recourse to public funds restriction on their leave to remain. So if you look at Appendix FM of our immigration rules, specifically under Gen 1.11a, it says that in general, a person who has been granted leave to enter or remain will have the restriction put for no recourse to public funds, unless they can show that they have any evidence to show that they are destitute under Section 95 of our Immigration and Asylum Act, or they can show that there's evidence that there are compelling reasons why they would not be able to maintain themselves because they have children, for instance, and they are low income. So that is what we generally have under Gen 1.11a. And then we have other case laws that have sort of provided the caseworkers who work for the Home Office with other, should I say, factors that they should be looking at when they are making their decisions. And last year, I know that a lot of people who were furloughed because of the coronavirus and people who may have lost their jobs were now looking to have these no recourse restrictions removed from their leave to remain, because it was important that they would have some sort of access when in their time of struggle. And so it was good that we had the R and W litigation friend case that made sure that it wasn't just the destitution factor that they were looking at, but they were also looking at the fact that if a person's circumstances have changed and there are compelling reasons why they should now have access to public funds, then the Home Office should do well to assess the evidence that has been provided and grant them access to public funds. And very recently, they put up their own research in terms of applications that have been made to remove no recourse to public funds. And of course, they said out of over 5,000 cases that came through last year, over 92% of those applications were granted leave to remain, and the restrictions were either lifted or they were not imposed on their leave, which is good news because previously you wouldn't have that amount of people being granted leave to remain without the no recourse to public funds. And then even now, we have this current case of ST litigation friend where the Home Office again is also come under scrutiny because they're saying that, of course, your guidance says that you should look at Section 55 of our Borders and Immigration Act, which of course shows that you should be able to put the child's best interest as primary consideration. But the court said that, of course, even though this is stated in their guidance, it is not mentioned particularly under Gen 1.11, where it says that the categories or the conditions under which a person will not have no recourse to public funds put on their leave to remain will be in situations where they can show they are destitute, or if they have compelling reasons why such a restriction should not be imposed. And it said that, of course, where there is a child, they should consider the child's best interest as paramount, because you are not only looking to say that because the mother is on low income or the father is on low income, and therefore we want to see if they have enough money to be able to meet their needs. But you should also consider the fact that there's a child or there are children within the family household. And even if the child is British, you should be able to say that because this person who is applying for leave to remain has restrictions to their leave, or even if they don't have restrictions and they have previously had access to public funds, that no recourse to public funds should not be imposed on them, even if they are allowed to pay the fee. So sometimes you have somebody who is able to pay part or all of the fees because they have some funds being received from the government, whether it's working tax credit, universal credit, whatever it may be, they may be able to pay part or full of their fees. But that, in any case, should not allow somebody who is looking at their application to say that because they have been able to pay for the fees, therefore that restriction should be imposed on them. And so it's important that they also look at the circumstances clearly, and if there's a child or children involved and the income is therefore not enough to be able to meet and maintain their family or the household, then that restriction should not be imposed on a person's leave to remain. So it's good that we have cases that actually back the factors that the Home Office should be looking at when it comes to removing or not imposing that restriction or lifting that restriction from a person's leave to remain. So yes, the conditions are not to, of course, impose it if a person is able to show that they are likely to be destitute, or that they have compelling reasons why their family or the child who is involved will not be able to maintain. They will not be able to maintain that child's need if they are on very low income, and also the fact that they should be able to put the child's best interest as primary consideration when making such decisions. Can you hear me?
Me.
Uh,
Can you hear me?
yes, I can.
Pixie says I was recently granted 2.5 years leave to remain as a British child. I have 2 other children with my wife who are yet to register as British. I recently lost my job as a self-employed driver. My wife also has further leave to remain but works part-time. What will I need when applying to have access to public funds?
Okay, so he's basically saying that because he's lost his job, he wants to be able to have access to public funds. And of course, with almost every application that you do with the Home Office, it is about the evidence you are able to provide. And so when you talk about evidence, we are looking at how best you can meet the conditions that they have set out under Gen 1.11a, and also the fact that if there is any other need that you believe will be necessary for them to know, they can assess that also based on a case by case basis. So in this particular gentleman's situation, we're going to be looking at the fact that he is making an application for a change of condition. So he already has leave to remain, but he wants that restriction lifted from his leave to remain. And so he's making that application for a change of conditions. It's an online application. Of course, once he's completed application, because it's free, they would send him a link where he can upload the documents, or he can either post the documents to them. And of course, they are looking to see that he's able to show his payslip. So at least his 6 months payslip to see the income that he's earned over the past 6 months. Of course, if he's now unemployed, he has to be able to show that he's no longer employed. And so if there's a termination letter, he can provide that because he says he's a delivery driver. So of course, maybe his contract has ended with that particular company, so he can provide that as well. And then of course, he should be able to provide evidence of his expenses. So if he has expenses in terms of their shopping, the bills that they have to pay, the rent, any debt letters or whatever the case may be, he can provide evidence of that, including his bank statements. The bank statements obviously show evidence of your transactions. So if you are paying for your essential needs, it will show on your bank statements. If you are obviously receiving income, which is a lot more, it will show on your bank statements. So of course they want to know how much you have coming in and how much you have going out at any given time. And then they can assess whether you have sufficient income to be able to maintain yourself and your family. He says that his wife is also working, so he will have to provide his wife's evidence of income, which will be her pay slips and the bank statements as well, and then any other expenses that the wife is also paying for. So it is not just limited to him, because of course he's living within a household and his wife is also working. So they would definitely request within the application if he's living with any partner or any dependents, and he'll have to list all of that in there as well. And so it's not just limited to him because he's the one applying, but he will have to show evidence of his partner's income. And anybody who is a family member, of course, who is working will have to provide evidence of their income and any expenses that have to be paid. And so, of course, if they are able to provide all of the evidence of their income and what their expenses are, and the fact that their income, of course, less the expenses, does not leave them with enough money to be able to cater for themselves and the children as well. And therefore, it is necessary that they would have recourse to public funds so that they can maintain themselves, including the children as well. So it's essential that they provide as much evidence as possible so that the caseworker looking at the case can assess it adequately. And they need to be able to also make further explanations if from the bank statements, for instance, it is not clear what the money is being used for. They can just annotate the bank statement to make sure that they have provided reasons for any expenses that are showing there. Yeah.
One, is there any time frame for the application to be to be decided?
Decidedly.
And second,
So,
go on then.
okay. So in terms of the processing time, before it would have taken about 3 months to make a decision, but now they are fairly quick. It takes about 4 to 6 weeks for you to get a decision on no conditions, a change of conditions application. So they are fairly quick with most of those applications. You have the odd ones where they take a bit longer, but generally within about 6 weeks you should get a response.
Threshold, the combined income, whereby let's take it back, just 5,000. The Home Office have any threshold, 50,000. Take care of. Needs support.
I could only hear a small section of your question.
Again, just asking, is there any threshold? I mean, regarding the combined salary. An example is, let's take it that the wife earns about 50,000 to 60,000 a year. So for applicant saying that he's lost his job, will the Home Office probably looking at the expenditure and everything say you guys can combine on just your wife's 50,000 to 60,000, or it doesn't matter the fact that one of them is just lost the job and wants to apply for recourse to public funds? Is there any threshold?
Okay, so the reason why they ask this is because they want you to be able to show that there are compelling reasons if you are on low income. So if you are on 50 to 60,000 a year, of course your income is not low, because of course you are telling them that yes, my wife works and maybe I've lost my job, but your wife's income, I'm sure, would be able to pay for expenses that you have and the children's essential needs. So if you are looking at it in terms of how the Home Office will assess it, you should be able to show that there are compelling reasons based on your low income why they should grant you access to public funds. And if you are saying that, yes, I've lost my job, and your wife's income is able to meet the expenses at home, then unfortunately you wouldn't have that recourse to public funds, because from the bank statements that will be provided, it would show clearly that if your expenses are, let's say, £1,000 a month, and your wife is earning how much, let's say your wife is earning 5,000 a month, then your wife's income is more than sufficient to be able to meet your essential needs. So in that case, unfortunately, you wouldn't have recourse to public funds.
Right, Eunice, in the absence of any further questions, would you like to round it up? Do you have anything else to say before I, bring the show to an end?
Yes. So I first of all would like to say that there are people in this situation where, for instance, for one reason or the other, they may have to make the application for the change of conditions because they are in serious circumstances where they cannot continue to go on to meet their essential needs and then pay for other expenses that they do have. And there are those who, for instance, will now be making their application for further leave to remain, and they also would want to know how best they can make the application so that the no recourse to public fund is not imposed on their leave to remain. And so, in all circumstances, of course, you can make an application for fee waiver if you do not have the funds to be able to pay for the fees, but also know that once they have granted you fee waiver, it doesn't necessarily mean that they will not impose the no recourse to public fund restriction. You have to go and show them evidence. So evidence is necessary to show that, of course, you will not be able to meet your essential needs, as well as the fact that maybe you are on low income, and so because you're on low income, the income you are getting is not sufficient to be able to look after your needs as well as the children's needs when such an application has been granted and you are given further leave to remain. And you therefore need access to public funds to be able to maintain yourself and the children involved. And so it's necessary that if you do need further clarifications or advice, you contact us and we are able to help or assist you in the best way possible. And also, we started the show by talking about our EU settlement scheme deadline of 30th June 2021. And for those that are currently in the UK, who as EA nationals or family members or those that have retained their rights, we are all aware that the deadline of the 30th of June 2021 is necessary. But we also have applications that have been made under our previous EEA regulation 2016. And it's important that people also are made aware that if you have made applications for EEA family permit, I'm not talking about the EUSS family permit. So EEA family permit to join an EA national living here in the UK, the deadline is the 30th of June 2021. And if they are granted permit after the 30th of June 2021, unfortunately, it will no longer be valid at that date, and therefore they would have to make another application, probably under the EUSS family permit, to be granted family permits to enter the UK by that time. And so it's necessary that we take heed and then make sure that we are keeping close eye on these things, because constantly the things that the Home Office have put on their website is always changing, and so we should take heed and make sure that we don't fall foul to these things. Thank you so much, Vicky.
Yes, please.
Okay.
Please.
Yes. So if you do need further assistance and you would like to contact us, as Vicky said, we are BWF solicitors. We are situated in London. Our address is the 4th floor of Anna House, 214 to 218 Tottenham High Road, London, and the postcode is N15 4NP. So N15 4NP. And our telephone number is 0208 493 7340. So 0208 493 7340. And my personal number out of office hours is 075 35 81 3910. Thank you so much, Vicky.
Thank all of you who tuned in, shared the state with us throughout the program, especially in Japan. Hi, and I would also like to thank our sponsors, BWF solicitors, Petition Estates Limited, for one day school, English Substitution Center. This Saturday, today, I would like to BWF will be live on Facebook, the community and the law program. And today I think they'll be discussing, can parents and their children apply to remain in the UK after 7 years of residence? So please tune in on their Facebook page at BWF Solicitors and join in the discussion. Thank you so much, and I hope you have a lovely Saturday. I hope to see you next Saturday, same time. Take care. Bye-bye.
BWF Solicitors, we take pride in our clients' service. As a niche law practice, we are conscious of the demands of our clients. We always offer a friendly, listening ear and sympathetic attitude. We've worked with thousands of people all across the UK in all areas of personal legal services. We have received great feedback and reviews from our clients. We are located at Seven Sisters in Tottenham on the 4th floor of the Anna House, right on top of the Victoria Line train station for your utmost convenience. We have a friendly office and provide all of the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence and conduct as part of our responsibility to uphold rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society accreditation helps to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. BWF Solicitors, we're here to help you with your legal services when you need us.
Victon Estates provides professional and reliable service to landlords, investors and tenants. Our mission is to ethically and honestly serve our clients. We won't make promises we cannot keep, rather. We present a clear picture of the reality we can offer. We are here to help you with long and short-term let, property management, cash buyers for quick sales, stop repossession, and mortgage arrears. For all your property needs, look no further. Visit us at www.victonestates.co.uk or call us on 07448619711. Victon Estates, your property is our pride.